I mean, you can't just say to me, Judge, it's too much money. You're not giving me a reason to say he overcharged you. You're not giving me a reason to say anything about the installment payment order because I don't know anything about it. I don't know how much you make. I don't know where you work. I don't know how many expenses you have. And I'm talking about the amount that he agreed, not the installment payment amount. Do I have Nichols and Ebert, PC versus Samantha Duclos?
Yes, Your Honor.
Good morning, Mr. Lampkin. Your appearance?
Brent Lampkin on behalf of Nichols and Ebert, PC.
Ma'am, your name?
Samantha Duclos.
Any resolution?
Not yet. I know we have discussed the potential of settlement, but I left it with Ms. Duclos, and I have not heard back from her since we last spoke about settlement. So
Ma'am?
No, Your Honor, we haven't. He offered.
I don't need to know.
Oh, okay. Sorry.
I don't really need to know what he offered. Are you opposed to accepting it or not?
I am not able to accept the conditions.
And because you don't owe the debt or because you can't afford to pay at the rate he wants you to?
The latter, yes, Your Honor.
So here's what could happen today. If you agree, and I don't care what you do. I can give you dates, we can set it for trial. But if you agree that you owe the debt, it doesn't make any sense to fight it. And there's two prongs of every lawsuit, essentially. One is whether or not the debt is owed, and two is ability to pay. So if you guys wanted to agree to a consent judgment on the total amount or whatever it is, including costs and attorney fees, I'll be happy to swear you to an oath today, and I'll determine how much you can afford to pay on a weekly, bi-weekly, or monthly basis. Does that make sense to you?
Yes, it does, Your Honor.
Do you want to do that, or you want to set it for trial?
My concern was the amount as well. I did question it with them, and that was where everything kind of started to happen. I questioned the amount with Mr. Ebert, who was my attorney at the time. And he said he would look everything over and get back to me. And that's kind of where we left that. So I didn't get a settlement offer from him.
Can I interject here? I want to bring something up with you. Mr. Ebert is on our court management council.
Okay.
They pass budgets. He's the treasurer of Brownstown. I know Mr. Ebert. I want to disclose that it's not going to make one difference to me as to whether or not it's Mike Ebert or whoever else in the world. I'm not going to treat him worse. I'm not going to treat him better. I'm not going to treat you worse. I'm not going to treat you better, but I want to disclose that. And if you have any questions regarding my relationship with him, you can ask me questions.
Okay.
Do you want to ask me any questions?
No, I have absolutely no issues with Mr. Ebert. He was a great attorney.
No, I just want to make sure that you don't have a problem with me handling the case, ma'am.
No, if there's no biases, I have no issues.
Okay, so tell me how far you guys are apart. Maybe I can help you. If I can't, I shouldn't really be getting involved in settlement negotiations a lot on a bench trial. To be honest with you, I don't do it.
Mm-hmm.
But if you guys are real close, maybe I can help. If not, fine. I'll just set it for trial. Do you agree that he did the work that he charged you for?
I was not sure of that aspect of it. I was concerned that in 2 months, my balance had accumulated almost $7,000. So I was just like caught off guard with that. And so when I
divorce is finalized now, right, ma'am?
Yes.
Were there children?
Done. Yes, there were children.
Okay. But I mean, do you have any questions about whether or not he did the work?
We're happy to try the case, Your Honor, if she wants to do that. And we'll stand by our work. Mr. Ebert will testify. There's also was communication with her a year ago about resolving the balance, and she was supposed to get back to him He has text messages that he supplied to me and I gave to her to prove that he was in communication with her. She probably just can't afford to pay it. So now she's questioning the charges, and I understand that position, but we're happy to just present that to the court if she just.
So, ma'am, it really is very simple. You can either tell me, Judge, I just want to go to trial. I want them to prove what the fees were, that they were reasonable and necessary to the handling of my case. Or you can say, you know what, I agree with the amount that they're seeking, and I want to just cover the issue of an installment payment order. It's up to you. I don't want to put you into bankruptcy, but they do have the right to have their money paid.
Right.
And so you tell me what you want. It's entirely up to you.
My only concern was the large increase, and it caught me off guard. And I actually reached out to Mr. Eberth first.
Ma'am, if you don't want to settle this, you don't have to settle this. I can just set it for trial if that's what you guys want me to do. It does not matter to me. I'm not trying to pressure you into settling, not settling. I could care less. So I can't resolve that right now. If you think there's an issue that maybe you were overcharged, we'll just set it for trial. If you want discovery, that is the exchange of information. I'll be happy to give you dates on that. Whatever you guys want to do, it's up to you.
Well, I was looking for more of a settlement amount because I can't afford to pay the rate he was asking for.
Well, you signed a retainer agreement at that though, right? Did you not sign a retainer agreement?
I did.
You had to think about that before you sign the agreement. I mean, I know lawyers are expensive, but there's a lot of hidden costs. You know, they're paying secretaries and all these other, office rent, malpractice insurance, postage, phone bills, you name it. There's a lot to that, but.
And Your Honor, this was not a simple matter. It got very complicated, and there were they had reconciled at one point, refiled again, had a pretty extensive mediation. There's a lot of things that we would be presenting.
So where's his total fee?
Yes.
How much was his total fee?
Oh, his total fee. I don't know that offhand. I do know the outstanding balance, but which is over $9,000 at this point. It is.
Was there a lot of court hearings regarding maybe custody issues or something similar, ma'am?
The final two invoices were for mediation. We had mediation one time, and that was the $6,400.
Yeah,
that's why I was caught off guard.
They're paying mediators. They're paying the lawyers. How much did the lawyer get paid? Do you know, that mediated the case?
We paid the mediator on our own.
Okay. How many hours did he include for mediation, Mr. Eberth or his partner or whoever?
I believe it was 2.5 hours, 3 hours, around there.
Oh, that's not much.
But he and I paid the mediator directly. I didn't have Mr. Eberth pay the mediator.
As Your Honor probably knows, it's not just the attending mediation and showing up for a couple hours to talk.
Preparing for it.
Lots of that. And there's lots of communication in the we send out monthly statements, Your Honor, that detail everything that we're doing on a file. And she would receive these every single month. And
you tell me what you want to do, ma'am. Do you want me just to set it for trial?
I don't personally want to go to trial, but I cannot afford the terms that he was looking for. I can't afford the monthly rate he was asking.
So that's why I said I would come in. If you agree that you owe the debt, you two can agree to a consent judgment in that amount. I can have a hearing right now for installment payments. I will ask you questions. You can testify. He will ask you questions. I'll determine how much you can afford to pay on either a weekly, bi-weekly, or monthly level, or installment payment plan. And if that's fine, we'll continue that now. If not, I'll just set it for trial, whatever you want. I mean, you can't just say to me, Judge, it's too much money. You're not giving me a reason to say he overcharged you. You're not giving me a reason to say anything about the installment payment order because I don't know anything about it. I don't know how much you make. I don't know where you work. I don't know how many expenses you have. So let's take one thing at a time. Do you want a trial or do you want to settle at the rate that Mr. Lampkin agreed to? And I'm talking about the amount that he agreed, not the installment payment amount. I can
Okay.
handle that separately.
I think I was just in the mental space of Mr. Eberth coming to me with a settlement amount because of the amount. So accepting the amount is difficult.
I'll just set it for trial. Do you guys want discovery or not?
Short period. I don't know that we need much, but maybe it might help to know some more financial information for that portion of the trial regarding ability to pay once we determine what the balance will be.
Give you guys until July 18th to conduct discovery. There will be no ADR. Witness lists in this case are due on June the 18th. Nobody demanded a jury trial, correct?
Correct.
I'm going to set the trial again for August the 24th, and that'll be at 10:30 in the morning. At 10:30 in the morning. Nobody has to file a trial brief. If you choose to file one, you have to file and exchange it not later than 7 days before the trial date. No voir dire questions, no jury instruction questions. I think that should cover it. Let me just see here. Two. Do you have any questions of me, ma'am? I'm going to send out this pretrial order. You guys should have it the next week.
Yes, Your Honor. What was the July 18th date?
That's the discovery cutoff. If you want to conduct discovery, you have until July 18th. So if they have documents you might want to see that would bolster your case or defeat their case for attorney fees, then you can go ahead and submit that, whether it's discovery for documents, interrogatories, depositions. It does not matter, okay?
Okay, thank you, Your Honor.
Good luck to you both. Thank you very much. City of Dearborn versus Irvin LeBlanc.
Thank you.
Thank you, Your Honor.
2505. Cortez Nakari Gordon. 2-678-42512, 2-678-43566A and B and C.
Good morning, Your Honor, to you and your staff. Attorney Maxwell Dubin, P number 86012, on behalf of Mr. Gordon, who stands to my right. Mr. Gordon, please state your full name for the judge. And Mr. Gordon, do I have permission to stand in for Attorney Tia Barakit?
Yes. All right. So he's standing in with your permission and consent, right? Yes?
Yes.
So he's going to plead guilty, it looks like, to operating while impaired. He's also going to plead responsible to speeding 5 over. And then the prosecutor is going to dismiss the operating while intoxicated as well as the open intox. Am I correct?
That is absolutely correct.
He didn't sign an advice of rights form today.
These are the same rights being heard. I did, for the record, Your Honor, I did go over it. Well, I apologize, it's on. You know, those are your rights.
So you understand everything that's going on here today, Mr. Gordon?
Yes.
Why don't you take your time, if you make sure you've read those and understood those rights, and you sign the advice of rights, okay? So if you plead guilty to operating while impaired, the possible penalties are as follows. The $300 in fines, 93 days jail, 360 hours community service, court costs are all 4 points. License suspension or revocation in accordance with your record in your vehicle could be, or might have to be immobilized depending upon your record. Do you understand that?
Yes, sir.
If you plead the speeding 1 to 5 over, that's 1 point, but honestly, you're only going to get the higher of the 2-point totals, so you'll get 4 points as a result of this plea to operating while impaired. Do you understand that?
Yes.
And you understand if you plead guilty to operating while impaired and responsible to speeding, I'm going to dismiss on motion of the prosecutor the operating while intoxicated, as well as the open intox. Do you understand that?
Yes.
Did you sign, read, and understand that advice and rights form here today? If you plead guilty, you'll be giving up all those rights, and we are not going to have a hearing or a trial of any kind. Do you understand that?
Yes.
All right. To the charge, operating while impaired, how do you plead? Operating while visibly impaired, how do you plead, sir?
Guilty.
Were you operating a motor vehicle on Van Horn near Ford in Woodhaven at 1:56 in the morning on the 5th of July of 26?
Yes.
Prior to that, did you drink alcohol? And if so, what did you drink and how much?
Right. To vodka.
You got to keep your voice up for me. Will you do that?
Yes.
2 vodka what? And were you at a bar or at somebody's house? Bar an hour and a half ago?
Drive.
You had 2? Were they single shots? Where were you? What bar?
Big Bend.
I-
Detroit. Big Bend, Detroit.
What were you doing down here? You live in Ohio, right?
Yes.
Were you on your way home?
Yes.
And was your ability to operate that motor vehicle impaired because of the consumption of the alcohol?
Yes.
Why were you pulled over by the police? Listen to me. You gotta keep your voice up. Okay, I gotta hear you. All right? Why were you pulled over by the police?
I was going 10 over.
You think you were speeding at least in part because of your alcohol consumption.
Yes.
Counsel, did he take was this a blood or a breath
It was a
result?
breath jar. It was a .11 and a .12, and the defense was stipulated that it was.
Are you on probation or parole right now?
No.
Anybody forced you to plead guilty?
No.
To the charge of speeding, 5 over, 1 to 5 over, responsible or not responsible?
Responsible.
I'll accept that plea. I'll accept the plea to operating while impaired. I'll dismiss the OWI and open intox pursuant to stipulation. I'll refer you for a screening and assessment. You're gonna be screened and assessed today, sentenced at a later time. Does he have any other prior drunk drivings?
Nothing, I've got very clean history. I actually a CDL before this, but I will address that.
I'm gonna order a screening and assessment. We're gonna give you a sentence date. And I am going to, I already said you can leave the state, no alcohol, marijuana, or illegal drugs. You cannot violate a law. You must appear in court as directed. We'll give you a sentence date. And then I'll address this other case that you have in front of Judge Husson. What do you have for me, Lisa?
September 2nd at 8:30.
Good with you, counsel?
Good with the 9 to 8:30
What's that?
8:30 a.m. You guys said?
Yes,
Okay, no problem.
8:30 a.m., September 2nd. I trust you've got the money to pay this other case. Why didn't you show up on that impeding traffic charge from 2026 that you got on April 19th? You didn't show up for your show cause August 12th. I'm gonna call the case again. It's Cortez Nokari Gordon, 26W842512. So
At the time I was driving, I actually completely forgot.
Forgot.
Yes.
Forgot.
So
Forgot to show up.
I didn't even know that because I figured I paid. I guess I didn't pay.
You never showed up at all on this. Didn't pay. You didn't request a hearing. You just let it go into default. And then you didn't show up for your show cause a week ago. I always tell everybody, Mr. Dubin, the title of my book will be "Don't Tell the Judge I Forgot." That's what's going to be my title of my book.
You know what? He's an honest man. I'd rather be honest with you than lie to you. If you forgot, Your Honor, he has been really good with.
How do you forget to pay a tip? I'd like to forget to pay my taxes. I'd like to forget to pay my insurance. You got all this money to pay now though, right? Tell me you got the money to pay this right now, since you've blown us off here for 4 months. So I don't have to send you to jail.
How much is the?
It was $237. Well, what's the total amount? Was it 272, Lisa?
Yes, 272.
Got that money to pay, right?
Nuts.
Well, I don't know what to tell you. Maybe next time you're gonna learn not to forget. Find the money. Where are you gonna find the money? You gonna go dig on the pool, or what are you gonna do?
Your Honor, if I might, and he's got great family support, and he knows, of course, I'd rather him be honest, and I always tell him to don't lie in court, be honest, and that's not in his nature. What I would ask this court to do, you give him till Friday to come in here and pay that. I assure you it will get paid. He's very responsible.
Where is he working?
He was working, but as a truck driver.
I see. And
But he immediately got terminated because of this case, which of course, as you know better than even me, that happens, and that's something he's gonna have to live with himself.
I am working now.
Where?
So that was
So you blew your job because you were driving and you were a CDL driver and you got your license. Oh, boy, that's not good. I would have thought you'd think more. How old are you? Gotta think. I'll give him a week.
I appreciate it. Your Honor.
Pay this by August 26th. But don't come in here and tell me you forgot again. You got it?
yes.
I'll make sure of that, Your Honor, no problems.
Right?
Yeah. Yes.
I don't know. That's what we'll do.
Thank you, Your Honor, great to see you guys, as always, I'll see you next time. Please, seconds.
Have a good day. Thank you. Yes, sir.
The judge had clearly reached his limit with Mr. Johnson. Despite hearing about his family's financial struggles and his wife's recent childbirth, the judge focused on Johnson's repeated failures to appear and his failure to contact the court. He firmly rejected the request for leniency, making it clear that excuses would not erase his responsibilities.